The Supreme Court came out with another decision, this one bad for unions. Bad immediately for unions, even worse because of the implication, to quote a character from Always Sunny in Philadelphia. They ruled on Wednesday that a California regulation allowing union organizers to recruit agricultural workers at their workplaces violated the constitutional rights of their employers. So let's give you a little more details. It involves a nearly half-century-old California regulation, which give union organizers limited temporary access to farm work sites. So they can't just be there all the time. They have a limited amount of time that looks like this. A union may enter such a work site for up to 30 days at a time, and it may invoke this right up to 4 times a year. When they're there, they get up to 3 hours a day to speak to workers, potentially the hour before the start of work, the hour after the end of work, and the workers' lunch break. So literally none of this is actually infringing on the actual time where people are working. Union organizers are thus allowed on a farm's property for a maximum of 120 days a year, 3 hours per day, and the union has to tell the employer when they want to use this right. So that's how it's worked for a half century, but apparently no longer. It was a 6-3 vote along ideological lines, and why not? Donald Trump got elected, so they got their conservative Supreme Court, which is why you get cases like this. They ruled that the law unconstitutionally appropriates private land by allowing organizers to go on farm property to drum up union support. Chief Justice John Roberts said, the access regulation grants labor organizations a right to invade the grower's property. That meant, he wrote, that it was a taking of private property without just compensation. So do the union owners literally bag it up and run out with it? Is it theirs now? No, but it's a taking. And that's really where the true horror of this in the future starts, which we'll get into, but I wanna give Dan a chance to talk about this most recent ruling.
I think the worst thing that stood out to me from this article was, from the story, was that consideration, the legal framing right there, that these unions are going onto farm workers' property without compensation. Because I think there was some legal analysis of this that went along the lines of, well, there could be some middle ground where the unions compensate the farm workers for being on their property for that time. But then it goes into what is that compensation? I think in that legal example that I'm remembering the quote from, it was like, oh, could be as little as $50. Sure. I think the idea of a $50 union tax is a form of union busting in that way from the judicial level, sure, but let's take that for granted. Do you think it's really gonna be $50? Or do you think that they're going to take that definition that's already very and purposely broad to say, no, we're going to calculate how much money we are claiming that the union would cost the company in profits or whatever, and we're gonna charge you that much to try to do it as another way of actually deterring people. So I think this is, as a lot of people are saying, a harbinger for having a conservative Supreme Court that is just unabashedly, unapologetically trying to get through policy agenda items that the congressional Republicans and the legislative branch don't have the ability to do yet.
Yeah, it's gonna be pro-corporate so that the Republicans don't have to actually try to pass bills to accomplish the same things. Activist judges, which they say they don't want. So why is this so bad? It's not just this California regulation. Let's give you a little idea from Nico Bowie had a thread about this on Twitter saying, the Supreme Court just declared that when a law temporarily limits a property owner's right to exclude, the government takes the owner's property and must pay them. Goes on to say anti-discrimination laws take employers' right to exclude workers of color, pregnant workers, and LGBTQ plus workers. Anti-retaliation laws take employers' right to exclude whistleblowers and workers who complain of harassment. It is not difficult to describe any law as taking something. The conservative deregulationists on the Supreme Court just said the government must pay for what it regulates. And so that is truly the potential issue here. It's not just this regulation, it's not just unions coming, although effectively allowing a corporation to decide how much they might need to be compensated when they have no interest in the union workers even being there. Thus, the regulation in the first place is scary enough by itself. But now, if taking something can literally be defined as not taking something, if that's what you need it to destroy some sort of government regulation, then I have no clue. I don't think anyone yet knows how broad that could go over the next few years with this Supreme Court. If they buy the nonsense in this ruling, I don't know what the limit of that is, or if indeed there is any limit. Let's find out together how bold they're gonna be. That's gonna be fun. This is another reminder, the Supreme Court is incredibly important. Control of it is incredibly important. That is a huge consequence of who becomes president. Just bear that in mind going forward. And final thought. You have like 20 seconds.
McConnell already said he would block a Supreme Court justice pick in 2024, 2023. So like, just so you know the game Republicans are playing, that's how serious it is.
Yeah. And Stephen Breyer, it's so fun to just wait. It adds a little bit of like tension, Why not have this be a 7-2 or an 8-1?
Make it a game show. Call it like LeBron's The Decision.
Exactly. For more political news breakdowns, interviews, stories of activism, and me trying my hardest to care about the occasional big celebrity news story, subscribe to our YouTube channel at youtube.com/The Damage Report. And you can ring the bell wherever it is so you don't miss anything.